We have one more bill to hear today. That is SB432. I will hand it over to our Vice Chair.
And with that, we'll open up the final hearing for today, Senate Bill 432. Madam Chair, whenever you're ready.
Thank you, Vice Chair Flores. For the record, my name is Melanie Scheibel. I'm the State Senator for District 9. Happy to be here to introduce the person who's going to present SB 432 to you. That is Mr. Marshal Willick, who I believe is present via Zoom. He is, so I will turn it over to him.
Thank you, Madam Chair, members of the committee. My name is Marshal Willick. I've practiced family law in Nevada for over 40 years. I'm a certified specialist and an AAML fellow, and was the managing editor of the Nevada Family Law Practice Manual. For more than 150 years, this body has repeatedly acknowledged that family law is different than other legal disputes and taken measures to protect the personal privacy of parties and children involved in family law cases. Today, those policy decisions have been endangered by a couple of recent judicial decisions, and legislative action is necessary to restore them. SB 432 is an update of a bill previously proposed by Senator Orenshaw, given new urgency by the Nevada Supreme Court opinions in Falconi and Nestor, which have ruled unconstitutional NRS 125.080 and two related local rules. The explanation of how we got here and how to address the resulting problems spans a great deal of time, but I will attempt to summarize and then answer any questions. The statute, now known as NRS 125.080, has been on the books since 1865 and was last updated in any way in 2007. The statute permits closed hearings in divorce trials upon the request of any party. Its purpose was to provide a measure of privacy to people dealing at trial with the most intimate and sensitive topics in their lives. It was written in an era when unmarried people did not have custody cases, and some children were still considered illegitimate. So on its face, it only applied to divorce cases. In 2024, in Falconi, the Nevada Supreme Court decided on a 4-3 vote that the statute was unconstitutional because all court hearings are presumptively open, and the statute did not permit the trial court to exercise its discretion to decide whether closure was warranted. The dissent correctly argued that family court was inherently different, coming from an entirely separate legal history starting in the ecclesiastical courts of England, and that this legislature had recognized the special privacy protections to be given litigants since 1865. There was massive confusion in the district courts. One judge in a case called Nestor said that given Falconi, he could not close hearings under any circumstances, since the Supreme Court had struck down the closed hearing rule. The Supreme Court reversed that decision in the Nestor opinion, saying that a district court does have the discretion to close hearings by applying its lengthy and somewhat rambling opinion in Falconi. Almost 100 years ago, this body enacted the sealed files rule, NRS 125.110. It's been on the books since 1931 and was slightly updated in 1963. In it, this legislature struck a balance between public access to divorce files and the privacy rights of divorce litigants and their children by making the complaint, answer, and reply, and all court orders and the final decree open to public inspection, while all other papers can be sealed as a matter of right upon the request of either party. Like the closed hearing statute, it did not consider the possibility that unmarried people would be in family court, and the terminology was written before there was such a thing as a video record or broadcasting or the internet. Now, the same people who targeted the closed hearing rule are attacking the sealed file rule, claiming that because it allows an order to be entered at the request of a party, it should be struck down so that no one has any ability to protect their financial, medical, or any other records in their divorce cases. SB 432 is a means of addressing all of those issues. Today, about half of custody cases are between people who were never married, and property cases between unmarried cohabitants constitute a large and growing percentage of the disputes between couples who are splitting up. So Section 2 provides an equal protection of the procedural rules to all family court litigants in all family court cases covered by Title 11 of NRS, including divorces, domestic partnerships, adoptions, guardianships, terminations of parental rights, premarital agreements, and other kinds of cases. Section 3 codifies the Falconi holding and gives guidance to the district courts as to how to apply it. It starts with the presumption, like the case did, that proceedings are open. It then lists factors that a court can and should apply in determining whether to close a hearing, including, of course, the best interest of the child, as stressed in Nestor, whether permitting third parties to observe or record the proceeding would violate a federal or state law, including laws prohibiting disclosure of personal identifying information, whether a child or party may suffer harassment, indignity, embarrassment, shame, financial loss, stigmatization, harm to reputation, or other emotional harm. This was also specifically mentioned by the Supreme Court in Nestor as a reason to close hearings. And finally, to weigh the fundamental privacy right of all persons, which various federal and state cases have also announced is a fundamental inherent right of people. To decide whether the closure serves a compelling interest, as required by the Falconi decision, the statute gives guidance to trial courts asking them to determine if the hearing is not closed, would an identified fundamental interest be harmed, and whether there are any practical alternatives to closure, as required by the cases. In subsections 5, 6, and 7, if the court finds that the proceeding should be closed, it gives the same directions as to who to include and exclude that this legislature has already determined is appropriate in the current statute. Subsection 8 provides that the electronic copy of a closed hearing is confidential and not to be distributed or broadcast. Subsection 9 enforces the rules giving courts a means to enforce their orders, closing hearings and sealing files. Section 4 of the bill updates and replaces existing NRS 125.110. Subsection 1, subsection A, keeps the balance between records open to inspection and what can be kept private from existing law. It's more specific in subsection B as to what records are not open to inspection, except by court order for good cause shown, including parties' private medical and financial documents, child custody evaluations, documents that are sealed by the court, and records that are prohibited by federal or state law from being copied or distributed. It then provides that everything else is presumptively open, but that the court can seal or redact any part of that everything else if it finds that sealing or redaction outweighs the public interest in access. The statute provides some detail so that personal identifying information that this legislature, or the federal government, requires to be kept confidential is defined as a compelling interest. For the first time, the statute specifies the conditions under which material can be unsealed, including stipulation of the parties, the court's own motion for good cause shown, or the motion of a party for good cause. The statute provides factors for determining good cause to unseal, including federal or state law requiring confidentiality, and whether a party seeking to unseal a record has demonstrated a legitimate interest to do so for a purpose related to the case, and echoing some very old case law, whether unsealing is being sought to, quote, gratify private spite or promote public scandal, and whether unsealing would subject a party or a child to harassment, indignity, embarrassment, shame, financial loss, stigmatization, harm to reputation, anxiety, fear, or other harm. Section 5 provides some teeth to the rest of the bill by providing for penalties for those who willingly violate statutes requiring the confidential information remain private. And Section 6 formally repeals existing 125080, which has been declared unconstitutional, and 125.110, which is now under attack. In conclusion, the right of privacy in parentage, custody, and divorce matters has been woven into Nevada law since the founding of this state, and it's been reaffirmed in legislative enactments and court decisions repeatedly since then. This bill intends to preserve the public policy determinations made by this body in 1864 and 1931, and many times since then, that the right of privacy is a fundamental right, which is a necessary component of the well-established right to personal liberty, which the Nevada Constitution guarantees is inalienable. This bill brings those public policy determinations into the 21st century, treating married and unmarried people equally in terms of their rights to privacy, and accommodating the newly found presumption of openness by providing for application of appropriate judicial discretion for both the closing of hearings and the sealing and unsealing of files. It provides structure for the district courts to make those determinations and properly respects the multitude of state and federal laws dealing with what information is open to public dissemination and what information is required to be kept confidential. Recent cases have made updating those old statutes a necessity. I urge this body to adopt SB432 in the interest of all people whose private lives and sensitive issues require their passage through the family courts. And I'll gladly answer any questions as to any aspects of the history or this bill.
And thank you for walking us through that history. Really appreciate that. Members, any questions? Senator Ellison, please.
I'm sorry, sir. I just have one. Could this be challenged, take it to the Supreme Court and be challenged the way this is written, or do you think this will be the law of the land?
Marshal Willick, for the record, of course it can be challenged. Anything can be challenged. And my guess is that the people who want open and free access to every aspect of every person's personal and private information will indeed challenge it. However, the core of the decision was not that closing hearings or sealing files is bad. They just wanted it to be a matter of judicial discretion. And so this bill makes it a matter of judicial discretion. So my guess is, I found that it's never a really good thing to guess what a court is going to do. But my guess would be based on the decision as written, since this bill enacts what the holding of the opinion was, that it will pass muster by that court.
Members, any additional questions? Seeing none, again, thank you for joining us and thank you for walking us through that history of the case. At this time, I'd like to invite those wishing to testify in support of Senate Bill 432. If you could please come forward, Carson City or Las Vegas. We have none in Carson City, but I do see some folk moving forward, I believe, in Las Vegas. Never mind. Seeing none in Carson City or Las Vegas, BPS, we have anybody wishing to join us on the phone in support of Senate Bill 432.
Thank you, Vice Chair. The public lines are open and working. However, there are no callers to provide testimony at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 432, Carson City or Las Vegas. We have none in Carson City, but I do see some folk joining us in Las Vegas. Good afternoon. Welcome.
Cody Gamble, CODYGAMBLE for the record. Chair Scheibel, committee members, good afternoon. Nobody ever regrets standing up for the truth. They only regret that they did not stand up sooner. On February 17th of 2024, I did just that. Not out of anger, but out of duty. I blew the whistle. I protected identities, including that of the opposing party, and I followed the law. I acted with integrity because there's not because there's anything good in me, but because of how I was trained as a Nevada Army National Guard soldier and as a father. Under SB 432, I'd be a Class C felon for that. My family court case was sealed, not after any findings, but upon demand of opposing counsel under the statute. No balancing, no discretion, no process, no room for me to object. Then a false allegation came, and I knew it was coming as soon as the case went dark. Predictable as gravity. It wasn't against me, it was against my sons. It split my family in two. CPS investigated, They unsubstantiated the claims. There was no finding, but there was also no accountability. And still, I couldn't get access to the records that I needed to protect the sibling bonds. The file was sealed by default. Later, I was falsely flagged by a technician for having photos on my phone of my daughter's eczema. There was no arrest, there were no charges, just a report. CPS got it. It lingered unproven and unexplained and uncorrected in the record, and it's still there to this day. Another unchecked claim behind closed doors. So I did what my military training teaches. When conventional tools fail, you go unconventional. You adapt, you go outside the wire, you find another way. When I argued this before the Nevada Supreme Court yesterday, Justice Pickering asked the question that SB432 cannot answer. How can anyone determine if a court order is fair when they can't see what was argued or the evidence that supported it? And that's the core issue. This bill doesn't protect families. It weaponizes secrecy, it shields dysfunction, and it criminalizes accountability. It punishes the very people who refuse to give up when the system breaks down. So SB 432 would make telling the truth when there's no other remedy a felony. And if that's the law, then I am guilty, but I will never be ashamed.
Thank you for joining us.
Good afternoon to the chair and the committee. My name is Alex Falconi, ALEX-FALCONI, and with exception of repeal, am testifying in opposition to this bill on behalf of the Nevada Open Government Coalition, the Nevada Press Association, and the Our Nevada Judges Corporation. We submitted detailed written testimony, which I urge this committee to review because I'm going to spend the remainder of our 2 minutes on other points. I also want to add that our written submission contains a reference to the Legal Aid Coalition's amicus brief supporting my position in the Supreme Court, but we want to clarify to this committee to not infer that they are joining us in opposition to this bill. As the law stands today, the judiciary is capable of closing the courts and denying camera access. The best example that I can give you is conveniently the case mentioned by the letter filed in support of this bill by a litigant politician whose claims unfairly portray the family court and fail to describe the lengths at which the family division goes to ensure that all relevant constitutional factors and privacy factors are considered before allowing access to their courtrooms. The family court judge did not rule in favor of the father in that case. In fact, she expressly denounced his failures to brief the public access issues. Instead, the judge independently came to the aid of the public, consistent with First Amendment principles. The judge specifically ordered that my cameras were the only ones allowed in the courtroom and that everyone else was prohibited from recording. The judge also closed the court for the portions of the testimony that she deemed appropriate. Efforts to curtail this discretion so early and without enough of a discussion could have very serious consequences, as Section 5 is so overly broad that it makes it a Category C felony for speaking publicly on issues that are not even limited to family court. Openness promotes public understanding, confidence, and acceptance of judicial processes and results, while secrecy encourages misunderstanding, distrust, and disrespect for the courts. Those are not our words. Those are the words of the Supreme Court of Nevada. No further comment.
And thank you for joining us. Is there anybody else wishing to join us in opposition in Las Vegas? Seeing none, we do have somebody joining us here in Carson City. Please proceed.
Good afternoon. Thank you so much for letting me speak. I promise I'll be fast. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. SB 432 risks limiting public access to records and hearings in a way that will lessen accountability. The bill allows for broad discretion to close proceedings based on subjective standards like reputational harm or emotional discomfort, terms that without clearer limits could be misused to shield misconduct or unfair outcomes from public scrutiny. SB 432 needs to be more narrowly tailored to ensure transparency and uphold the public's right to open courts. Thank you.
And thank you for joining us. Anybody else wishing to come forward? Seeing none, BPS, do we have anybody wishing to join us over the phone?
Thank you, Vice Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Perfect. We'll stay on the phone lines. Is there anybody wishing to testify in the neutral position for Senate Bill 432?
There are no callers to provide neutral testimony at this time.
Thank you. Anybody in Carson City or Las Vegas? Seeing none, at this time, Any closing remarks, Madam Chair? She is nodding her head. We are good to go. With that, we'll go ahead and close out the hearing on Senate Bill 432. And lastly, we'll move to public comment. Anybody wishing to come forward in Carson City or Las Vegas for public comment? Seeing none, BPS, do we have anybody wishing to join us over the phone for public comment?
Thank you. The public lines are open and working. However, there are no callers to provide public comment at this time.